Hi, welcome to another episode of Kidon, War Stories on the Cutting Edge of IP Monetization. My name is David L. Cohen. I'm the owner of Kidon IP, a consultancy, and David L. Cohen PC, a law firm, where we provide IP monetization services to clients both large and small. Every episode, I interview other subject matter experts and leaders in the wide world of prosecuting, asserting, analyzing, monetizing, and defending IP rights. You can find the show on YouTube, LinkedIn, Apple Podcasts, Google Podcasts, Stitcher, Spotify, and many more. Today, my guest is Richard Berry. I first met Richard when I joined Nokia as an in-house IP litigation team in 2007. Richard had recently joined from a prestigious law firm in London. Though it is possible we first met, or at least our wives may have met, at Cambridge many years prior, when we overlapped for at least a year or so. Richard worked his way up ultimately at Nokia, ultimately becoming a VP and head of litigation at Nokia, where he oversaw some of their most successful and important litigation and licensing campaigns. He is now a partner at Bird & Bird in London and focuses on various international arbitration and litigation matters. So, Richard, how did you get into IPs and SEPs? Obviously through Nokia, I imagine, but did you have prior experience, and how did you end up falling into that?
Yeah, so not a great deal, actually. I was at Linklaters, and I was doing patent litigation there, but not enough patent litigation. It always seemed to be that every time something interesting came along, there was a big merger or acquisition transaction which dragged us in, and we weren't seeing enough. But I was working with a Finnish gentleman called Ari Laakkonen, who had gone to join Nokia. And after about a year, he realized he had quite a lot on his plate. So he phoned me up and said, how do I like the idea of patent litigation, doing more of it and fewer corporate deals? And I thought, I'll definitely jump at that one. So I found myself at Nokia and suddenly learning all about how mobile phones worked and how SEPs worked and this whole world that we're now in.
And you ended up working your way up with quite a bit up all the way up the chain there. And so, when you were at Nokia, did you mostly focus on SEP litigation, or was it other stuff too? I know you did a lot of defensive work in the early days.
Yeah. So in the early days, Nokia was the big manufacturer. Everybody was taking a pop at Nokia. So on my first day, I arrived at Nokia. I was given a patent that was being asserted against us in Germany. I was given a plane ticket and told there's a hearing in Munich tomorrow morning. This patent related to UMA, which is mobile access over both Wi-Fi and the cellular networks. And if we lose, then we're going to be facing an injunction in Germany and 2 billion of lost sales overnight. So good luck. So there I was on a flight to Munich, frantically reading this patent, thinking, "Oh my God, what's going on? This is my first day, and I could be shutting down the company. This is terrifying." And I gradually got to realize that this was normal. There was always someone trying to shut down the company, someone asserting a patent against us, someone demanding royalties. And the answer was defend those you could, and take the licenses where we could, but this was the standard practice, and it carried on. We had tens of trials every year of some sort of patent infringement. Ultimately, with IPCOM becoming a monster of a case with 60 odd or 70 odd patents being asserted.
You had a very, very, I know people, you don't like to be reminded, but you had a very, very successful campaign. I think you had nullified most of the patents.
Yeah, all bar one. We had 63 straight wins and a loss, and this was the so-called 100A patent family, which is still around and is still being asserted against Vodafone and others today. But yes, we eventually we didn't win on one of them.
But ultimately, I think without patting ourselves on the back too much, but I think the Nokia in-house IP litigation team became the whole IP group became a pretty well-oiled machine, both on the offensive and defensive side, and got very sophisticated very quickly.
Yes, exactly. We started with, there was Ron and Ari being the originals. They hired me in, then Ari left, and then we had to build up a team. And by the time I left, there were 23 IP litigators within Nokia, and it was a really good team, working very, very well together, dealing with the offensive cases, the defensive cases. Everybody knew what they were doing, and it was very, very slick operation.
And what was interesting too is that because of everyone tries, a lot of it becomes mission critical or existential to the company very quickly with the threat of injunction, but also because of SEPs, which we'll probably talk about a lot very soon. It addresses a lot of complicated issues that are not sort of run-of-the-mill patent litigation, where it has politics and economics and trade issues and licensing issues, that it sort of encompasses a lot of aspects of the company. And I remember back in the Qualcomm litigation days, I felt like everyone in the company was involved. And I really think that we got, at least, I know in the European side, and you guys really were very good at getting everyone, all the various sort of herding all the various stakeholders into sort of a unified approach.
Absolutely, and it started with those early litigations were a shock to the company, but most of the company was getting on with the day-to-day work and were aware that something was happening. And I remember one of our first wins when the court had found the patents to be infringed but invalid. Obviously a win for a patent lawyer, and explaining this to our general counsel, saying that the patent was infringed but invalid, and her reaction was, "Oh Christ, we lost. We infringed the patent," and having to explain and to non-IP lawyers that no, the patent's invalid, so we've won, it's okay. Gradually from that sort of level, we got to the point where everybody understood what was going on. The general counsel, this was critical business stuff, and the senior legal officers, the chief legal officers of the company, knew patent litigation as well as we did. It was.
I sort of harp on that point because in my experience, now that I've left, and I'm sure you've seen it as well, there's a lack of experience in a lot of players across the space that sort of comes back to bite them because they don't understand how the game is played and they make a lot of dumb decisions. And on some level, it's sort of frustrating because I think, as we said it before the call, and I had a long discussion with Eric Stasic, who you know, and he was kept throwing arguments to me, and I kept showing him where they came from. That ultimately, not too much, especially in the realm of standard essential patents, has evolved. And what I mean is, we were both involved in the Nokia Qualcomm litigation, which sort of culminated in the Delaware Chancery lawsuit of 2008. And if you look at that litigation, I would venture to say there's almost no argument that's been raised in the past 15 years of SEP litigation that was at least not referenced in the litigation.
Right.
And I dared Eric to show me an argument that had it, and I was able to find reference. If you look at the briefs in the Chancery Court, it's there. And it's very frustrating because you sort of see these. Look, on the one hand, Nokia has done very well from this lack of sophistication. I think in the Continental lawsuits that they keep making the same arguments. But I'm sort of curious if you have the same impression.
Yeah, that's true. The difference, though, now is that we know how they play out. So right back at the beginning, we didn't even know if there was a FRAND defense. We were putting up these crazy arguments about FRAND and whether it was in competition law, whether it was in contract law. These sorts of creations of French professors for the very first time in contract law. And we had no idea whether this would work or not, whether it would fly, whether we would succeed. We had a number of judges who just looked at us and said, if you haven't got a license to the patent, you're infringing, and it's an injunction. It doesn't really matter what anything else says. And then you had other judges that sort of started to understand the idea. But now, of course, we know most of those arguments, which way they play out. Most of them have been answered. And new generations arise, the licensing level argument that we've just been through with Daimler and with Continental. That's a variation, and it's pretty much resolved now. But this is what's so fascinating. Having gone from this early start, when we really didn't know what worked, to now most countries, I would say, have a relatively harmonized view of how the FRAND defense works, what it is FRAND, what can be done, what can't be. And we're now in the really refinements, jurisdiction arguments, obviously the key thing that's going on at the UK at the moment between UK and China. But it is.
It was very satisfying, when we could quibble about the way it played out, but the Huawei VZT ruling the Unwired Planet ruling, and a
Yes.
number of others. It's finally like the highest courts in the jurisdictions are actually opining on issues that we thought were Hail Mary arguments or whatever phrase you prefer, like back in 2007. They're actually outlining what the arguments are and at least addressing many of the points.
Yeah, it was satisfying reading through the Huawei ZTE judgment, thinking, actually, this is all right. They've got it. They've got the points. It was quite pleasing and a massive relief as well, because the CJEU, this is the first time it had come across any of these arguments. Anyone who's worked with any trademark lawyers, they're always sort of tearing their hair out about what's come out of the CJEU and whether you can understand it or not. And Huawei ZTE came out, just reading through it, thinking, I'll take that. That's okay. We can live in that world.
Right. No, in sort of like reading the Unwired Planet decision when Judge Burst for the first trial court decision.
Yes.
I like the decision, but what was particularly satisfying to me was that every single argument that I've seen raised is at least touched there.
Yes.
And he understood what the argument was. He may not have agreed with it, which was just so satisfying as someone who's been playing in this field.
Yes, that's right. And there was the Vringo problem, which was the unresolved.
Well, you're talking to the Vringo problem.
I know you are the Vringo problem, I remember, but the Vringo problem of the low and the high and which one do you have to offer.
Right.
But Mr. Justice Burr said, there is no one because there's only one Frand. And then the Court of Appeal said, actually, there is, Frand is arranged, so the Vringo problem still exists.
Well, I think that's right. I mean, it's sort of part of the problem is that because of the nature of global licensing, it's impossible to force someone absent a litigation to agree to a global licensing right if they just don't want to agree. And so you either have this war of attrition or you have some sort of case where you try to resolve it. And the challenge is, of course, well, who gives whoever is deciding the global right the right to do that? And once you've decided you have the right to do that, you can't. The Vringo problem is a huge problem because if both are Frand, or Frand is arranged, that doesn't help. Now you can do what the Germans tried to do, which is that all right, we're going to grant an injunction because one is not Frand and one is Frand. But if they're both Frand, what do? It's like it does not compute. So a judge, and I give it to Burst, he tried to find a way. A judge is supposed to adjudicate and come up with a decision. And he tried, and he came up with a sort of an ingenious way to try to do it, whether you agree with it or not. And I think that's sort of one of the key innovations, I guess, that's actually happened. But I'm curious, in your view, sort of what sort of change really, how has the landscape really changed other than knowing how the arguments play out from someone who's actually trying to get something done, which is whether it's to license a portfolio or avoid having to pay a certain rate.
So it's definitely improved. There's a much greater degree of certainty now as to what can be done. There are mechanisms in place. If you have two parties who really, really can't agree, then each one knows what the playbook is going to be. There are always a little variations, particularly the creative strategy on behalf of the guy who thinks he's going to get sued, as to what he can do to preempt it, to drag it into a favourable jurisdiction. It used to be that you filed a preemptive case in ND-Cal or something like that, try and get your case into Northern District of California before the other cases in, let's say, Germany, the UK start rolling, or ITC or Eastern District of Texas. So the ND-Cal rate setting was a big strategy. That now seems to have been superseded by the China the rate setting case. And now
the more obscure the jurisdiction in China, the better, apparently.
Yeah, so Chongqing, for example, is the new one in a couple of Oppo cases. That's fantastic. I'm hoping I get a chance to go to Chongqing. I've never been there. It'd be a wonderful thing. There is a direct flight there from Helsinki, so it's it's possible. But yes, it's fascinating to see. One of the best parts of this job is seeing new courts and seeing new systems, and going and seeing the Chinese court system. Beijing was amazing. Shanghai. It's a very, very different way of doing it. The other one, of course, now, the jurisdiction that never featured but now is everywhere is India. So Delhi. Again, there are no cases I have that don't have some sort of Indian component to it. And this has become a fascinating thing. We always prepared there. We always thought, what about India? We never quite did it, but now this has become so key. And I think it's partly because it's such a big market.
It's partly because it's a big market. It's partly because there's a lot of politics there, anti-China. And it's I'll be damned if I let China set global rates. We're going to do it. And
yes.
I'm going to take a little credit. We educated the Indian courts about FRAND in Gringo, and in fact, I believe our former counsel now is one of the leading judges who's taking a lot of the FRAND cases, Mrs. Pratibha Singh.
Oh, of course, Judge Singh. Yes.
Yes.
I did not realize that he was one of your counsel. Okay, that's fair.
Yeah, she was our former, and she's a firebrand, and you don't want to cross her. But she knows the issues, right? We spent a lot of time. I think, to be fair, I think also Erickson used her a little bit, but we were one of her early FRAND cases, and we spent a lot of time educating her. So I think, and that's really what the challenge is, because I think, obviously you need a court system that sort of works, but you need judges who understand what the issues are.
Yeah, I always had, when I was at Nokia, I was always a little jealous of Ericsson. They always went everywhere first. So they opened up India before we had the courage to try it. They opened up Brazil before we had the courage to try it.
Hey, but I went to the Supreme Court of Brazil and upheld a preliminary injunction on an SEP.
No, so we were always a little bit more cautious in the litigation strategy and kind of following in Ericsson's footsteps there a bit. But India and Brazil now are huge markets.
They're huge markets. I mean, I think that's the interesting thing, and that's sort of. I'm curious what you sort of take of this thing about the competition amongst jurisdictions for FRAND rate setting. And just for our listeners, what we mean by that is the challenge is when you have a global portfolio that's subject to sort of certain restrictions on how to license it, FRAND. Who and how do you determine in a contentious situation the royalty rate for the whole portfolio? And you can either go patent by patent, but since no one usually licenses their portfolio patent by patent, you usually license it on a portfolio basis. How do you do that? And on what jurisdictional basis? And a number of jurisdictions, the UK, China, and a couple of other places have attempted to get global rate jurisdiction. And now there's a competition. And we can talk about the different ways that they've tried to do that. But what's interesting, at the end of the day, they're using brute force methods to encourage the litigants to adopt their royalty rate conclusion. And so, for example, in the UK and Unwired Planet, he issued, in the first decision, he did something what I thought was ingenious. You can, valid and infringed patent, you can either be injuncted, or you can accept our global royalty rate for the whole portfolio, which is X, after separate litigation. And which is, I'm making you an offer you can't refuse. The Chinese, on the other hand, are just doing it from the get-go. This is the royalty rate. But the power of the persuasive argument ultimately becomes how much do the litigants care about staying in that market. And it's sort of interesting, you're about the UPC, for example, if it goes the way of these other jurisdictions, that's a big market, and it'll really be able to set rates. UK is a decent sized market, and Apple, I remember, what was it in the Optus case that they threatened to leave the jurisdiction?
Yes.
But they didn't, because it was still 50 million people or something like that.
Exactly.
Probably quite a few iPhones. But China, on the other hand, is where everything is made. And where there's a huge market, and so they really have power, and it's a big windup. But I'm sort of curious how you think that this all is going to play out, given the overlap of this power politics play.
Yeah, so I have a theory as to how it can work out, and it's this: if you have two people and they agree that a court can set a FRAND rate, that's fine. TCL and Ericsson type scenario. Okay, it's probably a bad example, but from a jurisdiction perspective, the idea that two parties agree, this court is going to set a FRAND rate, and we will enter a license on those terms. And by agreement, that works perfectly okay. I'm not quite sure why you would ever pick a court rather than an arbitration tribunal to do that. But you can do it, and that should be fine.
Usually after exhaustion, to be honest, I think the courts, because they first fight, business fight because everyone has to beat their chest, and then eventually, and then they realize, okay, well, we're already in the courts. Let's do it this way.
That's fair enough. That's fair enough. So the alternative is that you have a court determining what a FRAND rate is as part of granting an injunction. Now, we look at the UK and we say, well, that was quite a stretch of your jurisdiction. You determined whether something was FRAND or not, but it was a step on the path to granting an injunction. Is it actually any different to what happens in Germany? No, not really. Not from a jurisdictional perspective, because what the German courts are doing is looking at, has he made a FRAND offer? Has one side made a FRAND offer? Has the other side made a FRAND offer? And use that to determine whether or not to grant the injunction. Now, so far, the German courts have been looking much more interested in behaviour rather than doing the maths on the numbers. But they're getting to the point where they're having to do the maths on the numbers because neither side is behaving sufficiently outrageously that the German court can just say, yes, it's clear, or no, it's not clear. So they're getting to the same place. Nobody's questioned that the German court's exceeding its jurisdiction or not, because they just haven't seen that. I think the ultimate and the end position of this is you either have parties agree that one court's going to do it, or if they don't, every court which is hearing an infringement case is going to have to come to its own view as to FRAND conduct. And it may be that they come to inconsistent views. And I don't actually see a problem with that, because in the same way that you might have the German court decide that integer 1b is infringed by flange A, whereas the English court decides that integer 1b is not infringed by flange A, we don't mind that. It may be the same wording, but courts can make different decisions. It may well be that we have a situation where the English court decides that the FRAND rate is 0.8%. The German court decides that on the different evidence it has before it, the FRAND rate is 0.6%. So you have a situation where the implementer decides, do I want to pay 0.6%? If I do, that's fine, I'm selling in Germany. Do I want to pay 0.8%? If I do, then I can sell in the UK. But if I don't want to pay 0.8%, then that's fine. I'm just excluded from the UK market. I can carry on selling in Germany because I'm paying the 0.6. Yes, it means that you're going to have different prices in different markets, different royalty rates in different markets. And not, it's not just a UK royalty rate. It's if you want to sell in the UK, you are having to accept a global rate that is higher. And that means your products are going to be more expensive in the UK. But that's okay. It's the same with pharmaceuticals. It's the same with many products. Different prices.
Well, I guess the question becomes if you can find a way such that devices that end up in the UK have the 0.8%, and the devices that end up in Germany and have the 0.6%. And the devices that end up in China have the 0.0005%.
Yeah. It's not quite the same, though, because it's different courts deciding what the global rate might be. And it means that you have to bring the entire fleet up to the same standard. So it would be a bit like the UK sets a particular standard for electrical safety. All of your products are going to have to meet that, because you're not going to have different types of products for different markets. And it's bring up the entire cost of the device. But to meet that single highest standard, your devices have to.
Well, I hear you. I was sort of joking, but the challenge is, I am a little less sanguine about the Chinese courts, given my experiences that I think I've told you about. But I've seen like they claim to have been implementers have claimed to have been injuncted from taking too high a royalty rate by the Chinese court, and there the question is, will if there is some sort of salad of different rates being determined by the different courts, because different percentages in different countries, will one of the courts say to one of the implementers, no, you can't take that high rate because I'm just making up a defense now, because it's an antitrust violation or competition law violation for you to pay so much, and because you're harming the consumer welfare by paying too much on royalties globally. So therefore, no, I know in the U.S. sometimes you have antitrust settlements are rejected by the courts as being a violation of the antitrust law, at least in the pharmaceutical context. So I'm curious whether that's going to be sort of a...
You see, I think it's where it starts to go too far, isn't it? It's one thing for a court to say, I have power in this country to decide whether or not to grant an injunction under a patent. You're infringing the patent. The starting point is that it's a property right in this country. I can regulate it. It's quite another thing for a court to start saying, I am going to regulate and prevent you from entering into global commercial agreements because I think that your commercial terms are not are too high or too low. It would have to be really extreme, I would have thought, for a court to exercise that sort of jurisdiction. And this comes back a little again to what Mr. Justice Burst said in Unwired Planet. There's a big difference between FRAND and being anti-competitive.
Yep.
A price that is so high that's anti-competitive, a price can be above FRAND before it becomes anti-competitive.
No, I think that's exactly right, and I love that framework, which is because there's often at least especially when I talk to the European lawyers in this space, a conflation between competition law aspects of FRAND and the contract law aspects of FRAND, and I think it is a two-band system. Like you agree to something with what that you contractually agree to something, whatever the heck it is, FRAND, and that's a bundle of stuff. And there's also some aspects of behavior that will otherwise be covered by FRAND that are covered by competition law, but competition law comes on the more egregious events. It's because it's too blunt an instrument, I think.
Yeah, I agree. And it's only competition law should only be regulating the extremes. I had some sympathy with Mr. Justice Burst when he said there was a single rate. And I think what he actually means is that if you had perfect information, you would be able to calculate a rate to a very small margin of error. I think that's what he means by that. So I sort of see this as concentric circles on a target. You got the bullseye, which is if you had perfect information, this is the rate that both sides would agree. Around that, you've got sort of FRAND, what's fair, reasonable, and non-discriminatory. And so long as you're somewhere near the bullseye, you're probably FRAND on both sides. And so then there's the range. And then the outer circle, the edges of the target, that's where competition law starts to come in and say, no, hang on, you're off the target here completely. I'm going to give you a push back in. But I don't.
I agree. I think though that he was more trying to. I think he was. My impression of Burst is that he's very practical, and he was trying to come up with he was asked to give an answer, and if you can't do what he did and join a global license and say, and the royalty rate is between 0.75 and 0.88. Like, whoa, okay.
Yeah. No, that's right.
What does that mean?
I also wonder if it was his inherent scientific training kicking in, which is that with enough information, there is an answer. But the problem is that we'd never quite have enough information to get it, which is why we actually think of error bands. So he thinks of FRANDs as error bands rather than a range, which is what perhaps people.
Yeah, no. I mean, fair enough. So where do you think this is all headed? In your special neck of the woods with the UK and Germany and with the UPC apparently is now happening. Although,
that's right.
And UK lawyers are going to be allowed to play if they do all the right things.
Well, yes, there's some limits on what we're allowed to do. Yeah, unfortunately.
Well, but at the end of the day, you're a solicitor. You never were arguing in courts anyway. So
that's true. Yeah.
So you could always hire some German guy to do the thing. But
hire some German guy. Yeah, that's right.
Hire some German guy to be your talking head. But it is a very different. It's going to upset the apple cart, and I'm curious how it's going to be.
Yeah. So at the moment, we have the litigation strategy in Europe is start with some cases in Germany, have some cases in the UK, probably as your second choice of jurisdiction, and then you're looking at the France, Netherlands, Spain, Italy, as it were, to add the further pressure. And a good litigation strategy has been to file a large number of cases in Germany, a small number in the UK, and then as those cases become successful in Germany, then file them more widely across other European countries. Now the UPC changes everything because we've suddenly got the ability with a single case to get an injunction that covers not just the 80 million people of Germany, but the 400 million people that are covered by the UPC area. And that is, from a patent owner's point of view, really quite attractive. Now, the big downside, of course, is that in one single shot, you can lose your patent protection from all of that area. But I don't think that matters so much for SEP cases for the big guys, the Nokias, the Ericssons, the Qualcomms, because the loss of one SEP family doesn't make very much difference. So
that does raise an interesting question because, yes, it doesn't because there's a hell of a lot of them. for many reasons that are sort of beyond, I think, would take us hours to talk into. But the big guys have a lot of them. But one of sort of the reasons they have a lot of them is that a lot of the SCPs are very incremental. How do I put this politely? Very, very incremental improvements of the prior art. And as you well know, I think you've written a piece on it. The success rate in validity for SCPs is not very good. And I'm curious, sort of, what do you think is going to happen at the UPC? Where and just one further thought here. One of the as annoying as expensive as UK litigation is, what I have found is that for these incremental improvement inventions, it's much better than Germany, because in Germany you basically are dealing with highly technical experts who really don't take evidence. It's all in the papers, and they're the kind of people like I used to joke about Judge Arnold in the UK. Oh, the internet. Oh, I did that in a year 4 science fair project. Oh, it's all obvious, right? So it's challenging. Whereas what we did, for example, at Marengo before Judge Burris with our patent, we provided a lot of evidence from the mouths of the people who were there to show that this, in retrospect, highly obvious idea was not obvious at all.
No.
And we provided proof, oral and testimony and written proof, and that was very persuasive to him, which is not something you can really do in the German system. And so, given that the UK is not going to be participating on the judicial level, we're talking about a civil law system that's probably more German than the UK now at the UPC, and the incremental improvements problem for SCPs. Are we going to see sort of a replay of the Nokia IPCOM validity suits with SCPs now? I mean, that's my fear at the UPC.
One of the problems, of course, is that there's two ways in which patents are invalidated. It might be that they're not novel or inventive, which is fair enough, or it might be that there was some sort of fault in the prosecution process. Loss of priority is a classic one, insufficiency, added matter. Many of the patents go down on those, or just the fact that they have prior disclosed themselves. The inventor has disclosed the patent before it's gone. And most of the IPCOM patents went down on those sorts of things, not that the Bosch guys hadn't made some good inventions. And the same is true. Well, it's very easy to criticize SCPs and say so many of these are incremental and so many of them are invalid. But when you step back and you look at the technology, the 2G, 3G is still, to me, absolutely mind-blowing. And this is old hat stuff. LTE is astonishing. The pace of development and what has been developed here is huge. There are clearly very good inventions that have been made all the way along. Now, there are faults in the patent system. That's because patenting is a fairly imperfect process. And many of these are incremental. But that's because by shaving half a gram off here and half a gram off there, the rocket flies.
Richard, don't get me wrong. I agree with you. And it's a huge improvement. But and it is very, very inventive. It's just on the paper.
That's right.
20 years later, it looks very, very obvious.
Yeah, what have you saved? Well, you've saved one bit.
Right. It looks very, very obvious. And what I'm concerned is that in the absence of oral evidence, in the absence of the ability to make the argument like you've made, showing all the documentary and the testimonial evidence that that's in fact the case.
That's right. It's harder. It may be. But equally, what the UK's got to do as well is, as you say, it's too expensive and it's too slow. With the UPC on our doorstep, the UK is going to have to get quicker and cheaper. Mostly quicker, actually, is the key thing.
Right.
We're going to have to find ways to speed it. You can't have a case that takes 4 years to reach a conclusion as to whether a license is needed or not, when the duration of the average license these days is now between 3 and 5 years.
Right.
It's not about. It's not.
Why does it take so long? Because my experience is that if you bring a singular patent case, infringement and validity in the UK, it tends to be relatively quick.
Yeah, you can get it through in a year, or you should be able to. One of the problems is we just don't have enough judges. There are the German patents courts. There are a lot of them, and they have plenty of judges. We just don't have enough, and that's partly a question of persuading our our government to make up more patents judges so that you can get these things through. And then you can get the cases listed more quickly. We also have, our procedure is suitable for big blockbuster pharmaceutical patents. And that same procedure ends up getting deployed for the SEP about saving one bit. And it's not suitable. We need to make our system.
What do you mean by that? Because I'm curious, because what do when you say procedure, you mean, what do you mean?
The 1.5 week trial, the experts who are in the box for 2-3 days.
Oh, I see.
All of the steps, the incredibly long, expensive, beautifully written expert reports, where you compare that to the German system, where you're there in 9 months. Yes, the papers by the time they get to the judge are that thick, but you haven't spent anything like as much money. And yet the German courts seem to reach the same decision as the UK courts remarkably often. The reasoning is good. I'm not certain.
Well, I think it's probably there's an inherent problem with oral testimony. If you're going to rely on oral testimony,
that's true.
That's to be fair. My baseline is the U.S., where if you can get a patent litigation done in a year, I mean, my God, that's a miracle.
Oh yeah, no, exactly. But you're not competing with the UPC that's going to be on your doorstep.
Right.
50 million customers straight off. So we're still faster than the US. We're still faster than India, but we're going to have to get a little faster. And the other thing, of course, is IoT. So
yeah.
Nokia and Daimler, big piece of patent litigation. The first of the automotive ones wasn't brought in the UK because the UK court would be too expensive. The average car manufacturer, the royalties are tens of millions a year, not hundreds of millions a year, and you can't have a litigation system that costs nearly 10 million euros to resolve a license that's tens of millions of euros a year. It doesn't work. So if Nokia versus Daimler is too expensive for the UK, you have to, the UK is too expensive for that, you have to start to wonder, what IoT case can we realistically bring in the UK? We've got to bring the whole thing down. Now, we can do it. I mean, we have every day courts deciding rental disputes over properties, over buildings. And that is very similar to France. You look at some comparables, and you come up with a number. The knockabout county court stuff could do that. We can do that in the High Court. We should be able to do it. We're just going to have to start.
Well, you should tap Judge. Isn't Justice first? Wasn't he the pioneer in the patents court?
Oh, the IPEC, yeah, that's true. Yeah. So but IPEC has this cost of this cap of damages, which is lower than, it's far too low. What we need to be dealing with is the cases between IPEC and the Apples versus Samsungs, where you can spend tens of millions quite happily. It's those mid-range ones. It's the automotive manufacturers. It's the guy who's making the modules. Those sorts of cases. You need to be able to get a results where you're dealing with the tens of millions of euros royalty per year, not the sort of hundreds of thousands which works well in IPEC.
Well, I think you need to write some rules of procedure and propose them.
Yeah, how to do this cheaper.
Yeah, no, I think that's fascinating. I think that's really fascinating. Well, there's a lot here we can talk about, Richard, and I know you're a busy guy. So, any closing messages for our viewers, and how should people get in touch with you? What's your preferred way to get in touch?
I would say the main closing message is it's so much better than it used to be. We whinge about FRAND, we whinge about court systems, we whinge about SEPs. We say it's all disastrous, impossible for an implementer to enter the market because of the threat of injunction, all of that sort of thing. But look at it, it's worked fine, and it worked fine when we really had no idea whether any of this sort of stuff was going to work at all. Now we have so much greater certainty. You can in cellular SEPs, you can tell pretty much what you need to pay for pretty much anybody to a reasonable degree of accuracy, and we're there. We need to make the other standards like that. Wi-Fi, I still have no clue how to work out who owns what in that.
And there's so much politics behind that too.
That's right. But if we could bring everything to the level of where we are on cellular SEPs now, I think that the world would be a much better place.
Awesome. So, and how do people get in touch with you, Richard?
Sure. So, Bird and Bird. Yeah, I have the advantage of a very unusual surname, so I'm very easy to find.
But notwithstanding it, you're still very steadfast. Well, listen, Richard, it's been a pleasure. Thank you. It's always great to see you, and it sounds like you're still doing exciting stuff. Maybe some other time we can talk about how to get into an airport past customs in under 7 minutes. I know that's one of your
the record at Helsinki. Yes, arriving at the airport to the plane pulling out in 7 minutes.
Especially now that travel's been gotten up, but hopefully we'll get to catch up face to face very soon. And thank you very much for this enlightening and fun conversation.
You're very welcome, David. Thank you very much.